Come to order. Court is again in session.
Good afternoon, Your Honor. Thank you. Sean Henry on behalf of the County of Monterey and all matters. For the court's benefit, and I think probably to the relief of everyone here, I only have three short matters I want to cover that should take me less than 15 minutes at most. Just to wrap up where we left off on the exemption process, I thought it might be a helpful exercise just to envision how this may play out very quickly. Counsel for the interveners put up a slide related to what happens on day one if measure Z goes into effect and what that might look like on the ground. So I thought I would just walk through a similar mental exercise with regard to the exemption process. So on day one, if the measure goes into effect, it creates, because of its prohibitions, potential non-conforming uses, as we've discussed during this trial. The county doesn't know of all the non-conforming uses that it would create because it doesn't have all the information about all the operations, but the county would develop a process to handle that through the ordinance process and the exemption process. Just like any other non-conforming use, there would be an application that would be brought. It would go through a hearing, likely with the hearing officer, and then to the Board of Supervisors. A decision would be made based on substantial evidence that's required by Measure Z, and then that decision would be subject to review, both in terms of the nature of the decision itself and whether it's supported by substantial evidence, and then separately by way of an inverse condemnation claim if people believe that's true.
Can I interrupt you for a second? Who can seek review of the Board of Supervisors' decision to grant an exemption or to grant an exemption?
As with any other land use decision, anyone who participates in the process and exhausts remedies and perfects their ability to challenge may challenge.
And in an inverse condemnation action, who gets to participate?
The property owner who believes that there's been an illegal taking without just compensation gets to file a lawsuit, and the county and the property owner would have a process in court, and liability would be determined, and if there's liability, it would go to a jury.
How long would the written review process take?
Well, it depends. I mean, I think in general, writ processes can be done fairly quickly. Obviously varies from court to court, but that process can occur, and as the Healing and Hensler line of cases made clear, you can file those both at the same time. So you don't have to wait. You can file them contemporaneously.
So what happens if the Board of Supervisors grants an exemption and then decides they're going to limit that exemption to whatever they believe is the minimum extent necessary to avoid the taking? Landowner doesn't like it. Files a petition. Some member of the public who participated in the process who didn't like it files a competing writ petition. And plaintiff at the same time joins an inverse condemnation.
So a great
Yes, I think this is.
well, I was going to say it's a wonderful law school question, but yeah, I mean that process, again, while complicated, technical, involving a lot of resources, that scenario does and can happen, because even though it's more typical that when a decision is made, one side or the other is happy and one is upset, there are decisions that are made where both sides file challenges. And so, again, I mean, we can come up with a lot of different scenarios and theories, this is a complex process, it will be. But it's something that the board and counties can handle.
Doesn't this differ somewhat from a situation where someone has undeveloped lands, or unapproved lands, plans to develop a piece of property which is not yet developed, or to seek a permit to change either the existing use allowed of a piece of property, and a situation here where you have large ongoing businesses which have to stop dead in their tracks and await the resolution of the proposed process for an exemption.
I'll assume for purposes of this discussion that they will be stopped dead in the tracks and there wouldn't be a way to address that.
I understand the county's position about what non-new wells means.
And I think there's probably other ways to work it out and address it in a way that's fair to all sides and gets past some of the complexities that are troubling the court, but let's assume we could do that. That is complicated, but the Livingston case that we cited is a situation where there is a, I'm going to mess up the details because it's one of those ones where there's an exception to an exception to an exception, but my recollection is that there was a change in the use and it affected people immediately, including ongoing concerns, and then there was an automatic exemption that was allowed, and then there was a way to then get an exception from that automatic exception. And so that's a complicated answer, but there are cases that have dealt with that type of situation before. And you can distinguish in terms of order of magnitude and the nature of this business versus others, but from a legal land use perspective, this is not atypical. It may be more significant in terms of impacts that you may have, but the process itself is firmly rooted in basic and well-settled land use concepts.
Where it brings an existing business to a screeching halt.
Well, we don't. We've given the court ways in which to interpret the measure that we think wouldn't create that situation. There's also other ways to deal with it, even in the measure itself. You may, and we heard that the industry doesn't believe that the amortization period and other ways to delay the effect of the measure are sufficient, but for purposes of a hypothetical, I can buy that argument, but we don't agree that that is exactly what's going to happen. We don't know what's going to happen necessarily. We think that the process that's set up is sufficient and can be made sufficient to implement it, and certainly at this stage on a facial challenge to it, it passes the requirements.
What is the substantial evidence language inclusion in section 6C designed to do? Is that for purposes of the initial determination by the Board of Supervisors? Or is that a standard of review that's to be applied in the later permit?
It's the typical standard that applies when boards make land use decisions and is included in here, and it is the standard by which the board has to make the decision regarding supporting its decision. And then the RIT review, it'll be subject to a RIT review, and whatever appropriate standards for RIT review would be applicable.
Which could be de novo review, if it's a vested right.
So there is in Hensler, there's specific language as to that question. It may not get exactly to, there may be, in the writ itself, one could maybe argue that it's either substantial review or some other, but I don't know the answer to that. I think that needs to play out. But what I can answer is that Hensler says that if that de novo review may be appropriate when the inverse condemnation component is included in the writ. If we go to slide 4, both in the papers and today there was a claim that Measure Z does not comply with substantive due process. We think Beverly Oil Company and Hermosa Beach, for whatever they may mean for preemption, which is a different question, but for this purposes, we think it answers the question. I'd be happy to distinguish the other cases if the court has questions about that, but we think that this fundamentally and squarely falls within the long line of cases that recognize that there's a legitimate interest here for municipal functions that clearly pass basic substantive due process requirements. And then if we go to slide 5, I'm not going to retread the ground that we've gone over on numerous occasions. I believe the court understands at least the county's position. It may not agree with it, but we've provided what the county believes, and I think dating back to the beginning has believed are reasonable interpretations of Measure Z. I think what I just would like to point out here is that, going back to where I started about this is an initiative and a general plan, the vagueness requirement at this stage, one, it has to be infamously vague in all of its applications in our view, and it's a very low standard at this stage. But the courts recognize, and Amador in particular acknowledges that in an initiative, and particularly when not Amador doesn't say this, but I'm making an argument particularly with the general plan as well, that there will be words and phrases which are assertedly ambiguous or uncertain, and that's to be expected at this point in the process. And as Amador points out, the courts have a role to play to help clarify any uncertainty. I've argued today, and the county believes that the county has a role to play consistent with the charge in Measure Z to help clarify those issues. Future courts, well, that is going to be a process. Future courts will resolve future issues. And our point today is that we believe that on its face, Measure Z passes this very low standard for vagueness requirements.
If under the county's proposed interpretation of no new wells, meaning no net new wells, how would that work? Say Chevron decides to cap and abandon a well. Who gets the credit to have a new well?
Well, I mean, that would be something that the county would have to struggle with. I don't know that we've completely thought through the specifics. I mean, we even just looked at it in terms of what the measure says, and that our view is that there is a number of wells, and the declarations of the Baker and O'Brien report actually contains a chart that shows what those are, and the measure itself talks about the number of wells. So the county would have to look through that. I think that it would just be an issue we'd have to address, so I don't have an answer. That's all I have.
Good afternoon, Your Honor. Peter Orradre for interveners. I think the county's explanation of the Section 6 exemption process was very thorough. I'd just like to add that the provision is intended to be protective of property rights, and it respects the rights of landowners and those who claim a vested right. And if applied by the county, as it says it is fully willing and able to do, with its long experience in applying these kinds of exemptions, making these determinations, the rights of all of the plaintiffs in these cases will be protected. And I think that's important for the court to consider going forward. I'd like to address the void for vagueness claims brought by Chevron today. And start by addressing the issue that void for vagueness is an extremely limited doctrine used in very rare cases to overturn ordinances and regulations. And in their briefing, the plaintiffs did not cite to any case applying that doctrine outside of the very limited world of First Amendment and criminal law cases, or they have one case finding not void for vagueness, where the civil law in that case allowed and empowered the state to act as a prosecutorial agency to assess criminal, civil penalties. But Measure Z is a land use measure, and it describes prohibited land uses. And the First Amendment cases that they rely on primarily simply aren't applicable here. And as we've pointed out a couple of times, this is a starting point. It's a general plan policy, and it will be refined as the county, pursuant to its administrative process, interprets the regulation, the policies, adopts implementing regulations, and applies those regulations to individual circumstances. And the Mission Springs Water District case that we cited in our brief, that's at 218 Calat 4th, 892, affirms that where initiatives are not penal and do not restrict speech, vagueness review is at its lowest ebb, assuming it applies at all. And there, I think it's instructive, the court found that an initiative that pegged the price, the rate increases to the consumer price index without defining that term was ambiguous, because there was what the court called a whole family of thousands of such indexes. But that ambiguity did not raise to the level of unconstitutional vagueness under the Due Process Clause. On the other hand, in Morrison v. State Board of Education at 1 Cal 3rd, 214, 231, a case cited by plaintiffs, the court upheld a statute proscribing, quote, unprofessional and, quote, immoral behavior on the part of public school teachers and found it to be constitutional. Measure Z contains specific prohibitions that supply their own definitions, and their detailed definitions, as we've seen. And plaintiffs are arguing here that these provisions are unconstitutionally vague, but at most, they've identified ambiguities that can and should, if they exist, be resolved by the county through its implementation of these ordinances, of these policies, excuse me. And Measure Z's Section 7H expressly anticipates this, and case law affirms the county's authority to do so. And in the Crichton v. City of Santa Monica case at 160 Calap 3rd, 1011, the court there explained that it is well established that where voters have altered their charter by initiative measure, but the terms of the amendment are ambiguous when read with existing law, the legislative body may interpret the initiative in order to harmonize it with existing law. An example of a potentially unconstitutionally vague land use measure would be something that said land uses that are risky land uses in support of oil and gas production are prohibited in Monterey County. This measure doesn't rise to the level of that type of vagueness. It explains explicitly what land uses are prohibited, and the claims that plaintiffs have raised go to the question of what is the proper interpretation of those, and the county has proposed interpretations. With respect to the new wells, the simple fact that there's a dispute between the county and the interveners over the plain-faced meaning of that interpretation does not give rise to an unconstitutional vagueness in that provision. The meaning of the new oil and gas wells is pretty clear upon its face, and the county can elaborate. At its core, I think this case is about direct democracy. It's about the power of voters to make collective decisions in their community through the ballot box. And the Supreme Court reaffirmed this earlier this year in Briggs v. Brown, that courts have a solemn duty to jealously guard the initiative power. And these due process challenges to this measure are an attempt to defeat a valid ordinance in the courtroom after being unable to defeat it at the ballot box. And the thrust of the argument that we've heard today from Chevron is voters are too unsophisticated to know what they're doing, and they don't understand the ordinance that they adopted by a majority in this county. And that's a fundamentally anti-democratic approach to interpreting Measure Z, and it asks the court to usurp the will of the people and their decision to adopt Measure Z and its land use protections, which must be respected here. Monterey County voters have spoken, and they acted to protect their air and their water and their communities from the well-known environmental risks and land use impacts of these activities. And we believe the court should uphold the will of the voters. Thank you.
Ms. Wells.
Thank you, Your Honor. I'm Heather Wells on behalf of California Resources Corporation. I'd just like to make 5 quick points. First, you've heard a lot about Section 6C being a typical land use process or in line with processes that local governments do all the time. That's not the case. Nothing like Section 6C exists. No one has cited you any case that addresses a provision that has the same terms as Section 6C. It's a form selection clause that will chill and delay claims that are fully within the court's competence, takings claims. It's as simple as looking at the text of Section 6C. The second point is you've heard that producers can go into this merry-go-round of review, and as long as we eventually get to court and we can eventually get judicial review of these claims, there's no problem. But that is an incredibly burdensome process to impose on particularly royalty owners, as you've heard about, smaller producers. And when the fundamental legal question that the board is asked to resolve is in line with what Your Honor would need to resolve, that doesn't make a lot of sense. And that's the reason why Hensler specifically addresses this question. The court says that administrative review of typical land use decisions is sufficient, but then goes on to the next sentence to say that administrative agencies are not competent to adjudicate takings claims. The third point is related to the first point I made, which is that the text of Section 6C makes clear that the board is not being asked to apply land use standards. This isn't a situation where there are substantive policy provisions that the board is being asked to review and consider. And as part of that general review process, the board should apply the statute constitutionally. The text of Section 6C has no land use standard in it at all. It has a requirement that the board make a finding that there's an unconstitutional taking of property, and that if they're going to grant an exemption, it must be related directly to that constitutional standard. It's not related to any sort of substantive land use standard. The fourth point I'll make, and if we get slide 3, Dorian, for these things. The next slide. To touch on the vagueness point briefly, the Amador case that the county just cited to you doesn't involve a constitutional right. It doesn't involve a chilling effect of these fundamental interests. And both the California Supreme Court and the US Supreme Court have recognized that this concern extends beyond just the First Amendment. The courts explicitly say, First Amendment or other constitutional rights, threatening constitutionally protected conduct, inhibits the exercise of constitutionally protected rights. And I think it's pretty hard to say that Section 6C is not directed at constitutional rights. That's the question that the board is being asked to resolve. And finally, just quickly, we've presented a lot of reasons why Section 6C is invalid, and we think it is. But as we've also explained, and as the court explained really quite thoroughly in the Action Apartment case that we've talked a lot about, the court has the discretion to decide that certain claims that present straightforward legal issues and can be efficiently and effectively resolved now do not need to go through even a valid exhaustion process or exemption process if doing so doesn't serve the interests of judicial economy. That's it. Thank you so much. That's your question.
Is there any case that addresses the notion of whether greatly delayed resolution of property rights is to be avoided, or may itself constitute a taking?
I think that is an issue that has been surfaced. Yeah, and in some cases as a question, but what you have here is not just a greatly delayed resolution of a property right that there's an assumption that it may be exercised at some point in the future. What's happening here is there's an express prohibition on the exercise of any use of these property rights. And as you've heard, this is a little bit different from CRC's position, but as you've heard from Chevron and Aera, larger producers, that immediate prohibition places a very significant burden on operators who need to be able to continue production operations to preserve their steam chest and other things that we've talked about. So I do think that that is a very significant issue in this case.
Thank you.
Thank you.
Good afternoon, Your Honor. Matt Ricochet, I'm Chevron plaintiffs. Just have a few points to go through. One, wanted to touch on something that was actually brought up by Mr. Renwick in his presentation. We do not agree that steam flooding would be allowed under Measure Z, and I think Your Honor picked up on that. This confusion just seems to highlight the ambiguity inherent in how this measure applies, that even the operators don't know what will be prohibited. And so how are they going to be able to determine whether or not they even need an exemption or what would be covered by the exemption unless they have some certainty? And apparently the waiting, according to the county, they believe that all these questions will be resolved in the implementation process. But the language of Measure Z and the distinction between the 5-year phase-out rule for underground injection versus the immediate prohibition on drilling and well stimulation indicates that there's some intent that those prohibitions are going into effect immediately. And in fact, in the briefing by the interveners, they complain about the fact that there's ongoing well drilling going on at the site. So according to their intent, they obviously feel that these prohibitions are going into effect, and on day one, operators will not be allowed to drill wells and will have to face the option choice of either stopping all drilling, potentially allowing the irreversible collapse of their operations in the steam flood project that they have invested in and seek an exemption, or continue their current operations and potentially risk enforcement actions and misdemeanor convictions and penalties. So this is the dynamic that separates this case from these other situations where that have been pointed out where there has been no vagueness shown. Most of the cases, like especially the Evangelides case involving the application of Prop 51, and whether or not there was joint and several liability to a pending personal injury action, something that court will be resolved in court. It would only come up in court, and at that point the judge would be able to interpret the measure. Here the impact would happen long before we're able to get to court, and would have to operators would have to determine how they're going to comply with this measure without knowing how the county plans to enforce it. And that brings it directly within the arbitrary discriminatory enforcement that the court held in Hunt versus City of Los Angeles. It was invalid as an impermissible employee. Also wanted the intervener cite to the Mission Springs versus Water District case, where the court read in a standard for the definition of the Consumer Price Index and held that it was not vague. This is a standard, a term that is pretty commonly used. And this conflicts with, or is easily contrasted with, for example, the acid maintenance and acid stimulation test, which is not something that is universally applied by agencies and common people and the business at large. This is something that is applied and created and overseen by DOGGR. And just go back to the document that we submitted to Your Honor last night. It shows, in fact, that DOGGR created this standard calculation that we showed to you on Tuesday in 2014 when it was enacting SB4. And interestingly, about 3 years later, well, to go back, as part of SB4, they also required all operators to submit information about any maintenance operation that involved the use of acids, even if it was calculated not to exceed the threshold, because they wanted this information. 2017, which is Exhibit B to the supplemental brief, they issued this notice to operators reminding people and making note that they have not been receiving enough of these maintenance submissions, reminding them this distinction between well maintenance and well stimulation, and that this, to the extent that any treatment may exceed the acid volume threshold, it must be demonstrated to DOGGR that it would not be well stimulation. And the division highly recommends, this is the quote language in the middle, highly recommends that operators consult with the division regarding any operation which may come close to the applicable thresholds. So this is not a test that can just be handed off to the county for them to apply on their own. This is something that DOGGR is taking personal jurisdiction over, for lack of a better word, and making sure that it's applied correctly. And that applies throughout all the operations that we're challenging as being void and as vague under Measure Z. They talk about the abandonment process. We've submitted documentation showing how DOGGR has set forth a policy encouraging the abandonment of long-term idle wells. And there's no discussion by the county of how this is going to coexist with their replacement scheme, which they still have not explained how it would work in any really even broad strokes. So for these reasons, we don't see any way that the application of Measure Z would be able to be implemented in a way that would provide sufficient standards for operators to be able to determine what's permitted and what's not, especially given the various conflicting interpretations that the county gives now, and which is not subject to, they're not bound by at this point, and they're not bound if strangers did litigation come in and try to enforce the plain text of the measure. So that helps.
Thank you.
Good afternoon, Edward Renwick for NARO and the 80 some odd mineral owners and royalty owners in Suffolk County. I'm going to spend a few minutes talking about I'm going to spend some few minutes talking about the problems of general plan inconsistency. And you do have a booklet that I've put together, and there's some 13 different documents there, and I will probably use very little of them because I've given the afternoon, we're in the afternoon of the last day. I'm going to cut to the chase on this one and move very quickly. What we are talking about is the application of Government Code Section 65300.5. That's under Item 1 of that little booklet, which provides that in construing the provisions of this article being the article dealing with general plans, the legislature intends that the general plan and elements and parts thereof comprise an integrated, internally consistent, and compatible statement of policies for the adopting agency. And just to cite you to a couple of cases that we have covered in our briefing, first is Napa Citizens for Honest Government versus Napa County Board of Supervisors. That is, I'm looking for the site right here. First it's in August 2001. Oh, here we are. That is 91 Calat 4th, 342. And Concerned Citizens of Calaveras County versus Board of Supervisors. That's 168 Calat 3rd, 90. The long and the short of it is that Government Code Section 65300.5 and these cases hold that you must have consistency between the elements of a general plan. And by the way, none of what I'm saying here detracts from all that's gone before on the subject of constitutional issues, on the issue of all the issues we've just discussed here before. But what I'm going to give you is an independent, standalone basis, which I think cries out for an order of this court setting aside Measure Z. I'm going to make your job easy for you, and that's what I'm going to try and do right now. This legal analysis is very simple. That LU 1.22 and LU 1.23. That's the wastewater injection, that's 1.22, and the no further oil wells, that's 1.23, are internally inconsistent. And there's nothing that can be done to fix it because Measure Z says that the only way to make any changes in Measure Z is to put it up to a vote of the public again. So we're stuck with what LU 1.22 and LU 2.23 say. And I'm mindful of the point you made this morning that when I referred to what LU 1.21 permitted, and you said, well, it doesn't really permit. It just says that LU 121 does not prohibit injecting water for various purposes. So, but when you look at when we look at L-1.22, it gives us a prohibited land use. That deals with anything that supports oil and gas wastewater injection or oil and gas wastewater impoundment. And when we go to 123, we see that the prohibited use is the drilling of new oil and gas wells. But it also provides that this policy does not affect oil and gas wells drilled prior to the effective date which have not been abandoned. So just strictly look at the language there. We can keep producing those existing wells, but we can't inject any oil or gas wastewater. And we know that you cannot produce wells in Monterey County, certainly in existing oil fields, without getting rid of wastewater, because we know that 95%, and this is not questioned, 95% of what we produce is water and 5% is oil. So it's a physical impossibility to produce oil and gas wells and not get rid of wastewater. You've got to get rid of the wastewater. We also know that it isn't economically feasible to put it into trucks and haul it off to Kern County or some such thing. You can't do it. And so you have a direct conflict between LU 122 and LU 123. And so what do when there is such a conflict that cannot be resolved because The Board of Supervisors is not allowed to make any changes in Measure Z. Well, about the only thing you can do is strike it down. At least those two elements of it. Now, if anybody accepts the county's view that although you can still you can still water flood and you can still steam flood and you can still cyclic steam, then guess what? We have a direct conflict, as so interpreted, between LU 1.21 and on one hand, then 1.22 and 1.23 on the other hand, you strike out the whole thing. That's my point. That is an independent basis for striking down Measure Z. Any questions, John?
Okay. Thank you, Mr. Mayor.
Donald Oldacre for Eagle Petroleum. Just before the county interveners respond to Mr. Renwick, I wanted to make sure the record reflected that my client would join with Chevron and Mr. Wickersham's remarks regarding the due process issue. And then with regard to Ms. Wells' remarks, specifically with regard to the effect of the process on smaller operators like my client and probably like Trio and Sunset. A smaller operator, such as my client, could not survive that kind of process. They simply do not produce enough oil and they do not make enough money in order to plan for the abandonment of their oil and gas wells, their injecting wells, and their facilities to be able to forestall beginning that process for years while they're waiting for the administrative process to run its course and then to enter into the court process. They would have to immediately, as our expert Mary Jane Wilson says, allow their contracts to expire. They would have to pay termination fees on contracts, and they would have to begin the process of planning, applying for, and undertaking the plugging and abandonment of their producing wells and their injection wells. And the consequence of that would be the loss of all of the value of their producing reserves, which is their real property interest. That's an interest that they own under their leases. They are given the right to produce that oil, and that is the only property right that they have. They have a right, both under their contract and under 3106B, to put surface installations on the property for the purpose of exercising those rights, and Measure Z takes that away instantly with regard to new wells, and takes it away in the very near future with regard to water injection wells, making it impossible for them to conduct their business. So in between Chevron and Aera, which have massive facilities and many properties and have cash flow from other sources that they can use to survive, and CRC, which has no wells and would lose all of its property value, my client and the smaller operators sit with a field or two and enough cash flow basically to plan for the abandonment at hopefully a minimal loss of their investment. Well, a total loss of their investment, but a minimal negative loss. They would have to dig into their pockets to plug and abandon their wells and their facilities in order to comply with this measure.
Thank you, Mr. Wilson.
Thank you.
Your Honor, just the record is abundantly clear on behalf of Trio and Sunset and Monroe Swell JV. We join in those arguments from counsel from Eagle. Thank you.
Thank you.
Good afternoon, Your Honor. Sean Haggerty on behalf of the county in all cases. With the general plan. We go to the second slide. And here are the standards that apply to your review for general plan consistency. The last bullet point is the one that's most important here. On the face, you need to presume validity, not second guess the wisdom of the decisions that are made in the general plan, particularly when an initiative is involved, and look to inconsistency on this face. The papers address other alleged inconsistencies in the general plan. I won't go into those. I think the papers answer those. Just to respond to the argument made in the papers and then here today with regard to the internal inconsistency in Measure Z. We've had a lot of testimony under different bodies of law regarding these words, what they mean, how the courts to interpret them. I would say that we're in a different, we need to view this through a different lens, and that's the general plan lens. And while everyone in the room here from industry who may be affected by these provisions may not like it, there is a way on its face to read them as being consistent with one another. We're dealing with 3 land use prohibitions. In one of those, in 1.23, there's a carve out or grandfathering of existing oil and gas wells that were either active or not abandoned as of the effective date. The measure allows those to continue. The measure also either prohibits other things with some exceptions, and we've argued about steam flooding and other things. Those can continue under the measure. They may not continue in the way that is consistent with the interest or the plans, business plans of industry, but they can continue. And so there's not an internal inconsistency on its face. You may not like the result, or people may not like the result, but through a general plan lens, the provisions here pass muster. They're internally consistent and can be read as such. Thank you.
Thank you.
A brief response, Your Honor. There is no way you can continue to operate wells under 1.23 without getting rid of wastewater. And 1.22 says you cannot get rid of wastewater by the only method that we use, which is wastewater injection. That is clear on its face. The only I suppose it is not clear on its face to those who are ignorant about the oil and gas business, but if they know the first form living thing about the oil and gas business, they know it's a physical impossibility.
Thank you.
Your Honor, Peter Broderick, Frederick Mears, we join in the county's arguments on the general plan consistency issue. And I would just like to add that on the face of these prohibitions, it's clear that they are exclusively prohibitions and they do not come with any or confer any rights or guarantees that any party will be able to continue any specific activity. So read discreetly, each of these measures is simply a prohibition. And I'd like to address, because Mr. Renwick brought it up directly, LU 123, which specifically says the drilling of new oil and gas wells is prohibited on all lands within the county's unincorporated area. It goes on to say this policy does not affect oil and gas wells drilled prior to the effective date and which have not been abandoned. So the policies do not, they're self-contained, they're prohibitions exclusively, and they don't convey any affirmative rights that might be interfered with under plaintiff's interpretations of the other policies. And with that, I'll conclude my remarks. Thank you.
And Your Honor, I think I am would say, I don't need to repeat what I just said.
Good.
So, Your Honor, I think we're done.
Not clear.
No? Well, I was hopeful we were done.
We're close. Go ahead.
Well, all I wanted to say, Your Honor, was is that I think I can speak on behalf of everyone. We really do very much appreciate all the time and effort that the court has gone through to master all of the intricate details with respect to all of these operations, as well as, of course, the very difficult and taxing legal issues that have been presented. And we greatly appreciate the time of the court and the court staff in preparing for these proceedings. And I just want to thank you.
I second or third, whatever it is, those thanks to the staff and everybody. It's just cases like this that have this much public attention put a special strain on the courts and the staff, and we all recognize that and appreciate it. And this is run like clockwork, and it's been a pleasure to be a part of. There's one piece of housekeeping that I wanted to attend to. This may be an unnecessary formality, but just for purposes of record clarity, on behalf of all plaintiffs, I move into evidence the administrative record, all the declarations and all the other evidence filed and or submitted in this matter. Of course, I understand that the evidence is subject to previously made objections upon which the court will rule.
And my current plan is bringing folks back on Monday just to address objections. Just to address objections. I mean, I've got 55 pages of them. I can alternative I'll rule on it. Yeah. Towards decision.
We prefer the
Latter
latter.
very much.
You know, I can
argue whether we, and I think we should probably do it. I'm not certain whether, given what's occurred here, we do this in writing, but given the court's desire to defer ruling on these in order to determine relevancy after hearing the parties' arguments, we believe that there should be further argument.
Well, you know, typically when objections are made, that is a court rule. The only reason I didn't do it here is because the issues weren't clear, and I had stacked objections as long as the most trial.
Well,
So you know,
if the court doesn't want to hear argument, we should do it perhaps in a supplemental brief.
I'm saying is I don't think anything that further needs to be said. I can rule on these. I can decide what it is. I just didn't know if you wanted to be here when I did.
And Your Honor, I think that's well within your discretion under the rules to make that determination. And so we don't think coming back is necessary.
Again, I would request that we fill out supplemental briefing on some of the evidentiary issues that have arisen during the course of this proceeding.
I don't see the need for something else. I've got no briefs that cover all the issues and what's relevant and what's not. I can make a determination about whether it's relevant or it's irrelevant and
Then another piece of housekeeping. I do want to, one more piece of housekeeping. I do want to confirm that none of the parties' presentations of PowerPoints are being moved into evidence, because we would object to all of that as hearsay.
no, those are basically arguments.
Yeah, we agree with that, Your Honor. What we've done in other trials like this is so that the record is clear of what was presented. As we've been presenting them to you, they are lodged. They are not moved into evidence, but there's a record. Because, for example, Mr. Boutros would have said, I'm reading from this slide and it says this. The record's not really complete unless the slide is there. So they're not being moved into evidence, but the typical procedure is to lodge them, and we would meet and confirm with the other side in terms of what was actually presented.
Which is fine. I mean, there should be a record of what they put up on the screen, what was argued for everybody's objection, really, for a complete record. But as I understand it, I'm going to rule that nobody's PowerPoint coming into evidence. That's demonstrative let you know. We deal with that routinely all the time in jury trials and court trials. It's helpful for the court to follow, but it's not.
And one further housekeeping point, the county has submitted a signed copy of the ordinance.
Oh, yes, thanks for bringing that up. I think what I instructed the clerk is, Mr. Tanaka, you can simply submit that with a cover sheet as a supplement to request for judicial notice. You may have done it already.
I've already.
And plaintiffs have no objection to it. It's being noticed, Your Honor.
It's just basically it.
If it were only that easy for everything else.
Your Honor, one thing,
Yes,
if I did not submit my PowerPoint presentation in writing to the court, I would like permission to lodge it with the court no later than Monday.
Well, you can if you want, but, you know, we're looking at copies of the dailies. They're not official. I haven't found out, it's just that I've been taking notes and there wasn't about the presentation.
Finally, as well, Your Honor, we have not forgotten the court's request for a chronology of the statutory enactments, and we hope either to file joint or separate ones within the next few days.
That'd be great. That'd be great. I mean, I general feeling, I can't tell you from memory when 3106D was amended the last time, or what the language was that was changed.
We'll be submitting that either jointly or if not, we'll submit.
Oh, yeah, they could separately. I mean, there may be, actually, there could be some disagreement, which is why I said jointly if you can, separately if you can't. It would just be a tremendous assistance.
We'll aim to get one. I said we'll aim to get one.
We may or may not.
We won't, but that'll be our aim.
That's good. Neighbors required.
And I also, on behalf of my clients, I would very much like to thank the court and the staff for its courtesy and attention.
We will. Yeah, Mr.
Do it.
I'm paying one of the arguments. All right, just one. All right, and now the glossary, I think it was mentioned, there was somebody mentioned, I think for interviewers, perhaps there was no objection to the glossary.
That's correct. I don't believe we're objecting to the glossary.
Okay, all right. It's just one of the things I didn't listen to in the trials. I always read all these materials. Pretty much knew where I was going. That should do it. I anticipate just getting all in the combing through things, but basically I do hope to get you a decision very quickly on this, because I know everybody wants finality, at least finality in this court. Okay, so that's it.
Already submitted.
Thank you very much, Your
Thank you, Your
Honor.
Honor. Thank you.
Today, the arguments were very technical, very complex legal processes that we've never been. A little overwhelmed by all the detail, but that's what they're doing. Both sides have to say, but we haven't become at any time. How do you feel? You're not going to speculate. It's always possible that quite like they will have to oil industry has a lot of money and a lot of lawyers, and they do a lot of legal arguments against Measure Z, so it could be a little while until we get the decision. How are you feeling as we now await? We feel really good about this opportunity to defend Measure Z in court. It passed because of the passion of the people of Monterey County and the incredible support here in the county for these important protections. And we really enjoyed this opportunity to talk about all of the court decisions in California that have upheld ordinances like Measure Z. We're hopeful, and now we're just really looking forward to getting this decision, and we are committed to standing with the people of Monterey County as long as it takes to defend Measure Z. It's very likely that whatever happens here in Superior Court will be appealed. Yes, and it could be a very long road to defend Measure Z. Measure Z is of national importance, and the oil industry is throwing everything they've got to try to defeat Measure Z. So it could be a long road to defend this, but we are committed to walking that road, and the voters in Monterey County affirmed last November that they think it's a road worth walking. Thank you so much. Thank you. Thank you. How are you?
Well, I think our attorneys did a very good job of presenting our case. We think the initiative is pretty straightforward, not as complex as the other side would make it out. It says what it says, which is that we don't want any new oil wells, and we want to phase out wastewater injection, in a reasonably short time, and that we don't want them moving on to the Monterey Shale and fracking or acidizing it. I think everybody in the county knew what we were driving at. I think it was kind of insulting that they questioned the people and their wisdom. I think it says something about their point of view as to what they feel about democracy. That somehow the people are not suited to make these kinds of decisions, but I beg to differ.
Thank you so much. Thank you. Okay, so we have officially wrapped up phase 1, and we're now meeting the president. The judge obviously has a lot of very detailed and complex information to review. He did indicate that it would be very quickly. We don't know what that means, and so we will wait and look forward to the judgment when that comes. A lot of the discussion today was on the voters incredibly important, and also kind of about the due process element of Measure Z. Regarding the due process, what are your thoughts on that?
So many of the arguments today were so highly technical. So if you're looking to get really technical about due process, I'm going to find an attorney for you to talk to, because that's not my expertise.
Okay. Anything? Assumption is waiting for the decision now.
So now, we feel that we have a very strong case. We put that case forward, as did the other side. That's why we have these processes, and we go through this court hearing. And it's unfortunate that we're here. It was maintained from the very beginning that this was going to be a taking, and it was going to be a burden on the county, and it's proving